this begins the second oral history interview session with retired New Jersey Supreme Court Associate Justice Stewart Pollock in Morristown, New Jersey on July 19th, 2017 with Sean Illingworth for the Rutgers Oral History Archives New Jersey Supreme Court Oral History Project. And Justice Pollock, thank you so much for sitting down with us again.
Once again, I'm delighted to be here.
All right, wonderful. Today, I would like to start by getting into some of the biggest cases that you wrote opinions for during your tenure on the Supreme Court. To begin, the Right to Choose versus Byrne case became one of your most notable cases. Can you tell us a little bit about your involvement in that case?
Well, the case concerned the constitutionality of New Jersey's version of Medicaid for pregnant women. Mm-hmm. And the statute as it came before us provided health care benefits for women who carried a child to term or who terminated the pregnancy to protect their life but not their health. Mm. And our court ruled that the statute was unconstitutional under the New Jersey Constitution to the extent that it eliminated protection to protect the health and life, the health of the mother. And there were several significant features about the case. One, we went farther than the U.S. Supreme Court had in protecting the health of the mother of a pregnant mother. And this led to a discussion in the opinion of principles of federalism and to what extent states can grant rights greater than those granted under the U.S. Constitution. And then it also involved an interpretation of the New Jersey Constitution and rights that had been found in that Constitution, although not expressly stated. This, most notably, the right of privacy and a right of equal protection of the law. And you're quite correct. The opinion was controversial. It did attract a lot of attention. There were two separate opinions. Again, one said that we had gone too far, and the other said we hadn't gone far enough.
Now, this was also dealing with the Hyde Amendment.
Yes.
Correct. How did the outcome of this case affect that? Did that circumvent it in New Jersey?
Well, all the case did was to say that New Jersey, in protecting the rights of pregnant women, was not limited by the Hyde Amendment, and that under our Constitution we could grant greater protections than were accorded under the U.S. Constitution and under federal law. And that had implications for cases that arose in other areas where the issue of the extent to which state courts could go in protecting fundamental rights of people. In criminal law with search and seizures and so forth. But you're quite correct. It did attract a lot of attention across the country for the principles that I've mentioned. Mm-hmm.
I'm curious also, in your work, you dealt with obviously some lightning rod issues, like in this case, abortion. Did that ever result in any, volume of disagreeable mail or any kind of public backlash that you had to deal with?
Yeah, understandably, there were people who disagreed with the opinion. These are issues that touch very sensitive nerves, quite understandably, for people. And the most notable example of disagreement surfaced when I came up for reappointment, and at least one group came and testified against my reappointment, and primarily because I'd written this opinion.
But as a sitting judge, you wouldn't be receiving hate mail or things like that, or would you be aware of that?
I can't remember. I suspect I did. I know Justice Harry Blackmun, who wrote Roe against Wade, received baskets full of hate mail, and through a series of happenstances, I developed a fairly close relationship with him and with Justice Brennan. Just as a footnote, Justice Brennan had delivered a speech at the New Jersey Bar Association, which later became the basis for a famous article in the Harvard Law Review, where he urged state courts to look to their own law, their own constitutions, and other forms of state law to grant greater protection than was granted under the U.S. Constitution. But I know I didn't get anywhere near the volume of mail that Justice Blackmun did because of Roe against Wade.
Now, another case from that year, 1982, was Newburgh versus Arrigo, which dealt with the responsibilities of divorced parents to pay for college educations.
Yes, and that was another one that I think remains controversial and remains the subject of constant attention. And what I said was that and depending on what the court said, and I wrote the opinion, was that in appropriate circumstances, the obligation of parents to support their children did not end when the children attained the age of majority, but that it could include an obligation to pay for college. And I know the law has changed since then. I think there have been some statutory amendments and so forth. But you're quite correct. That was another opinion that quite understandably attracted attention and, in some instances, disagreement.
Now, for a decision like that, going back to an issue we raised yesterday, the idea of bringing other justices around, and can you kind of use that as an example? Like, did you have to, do that kind of convincing on an issue like this?
I don't think I did in Newburgh or Arrigo. I think the court was unanimous. I may be wrong on that. That was not true with the right to choose against Byrne case. But it's quite understandable that on these very sensitive issues, not only will members of the court have different views, but members of the public will also.
Now, you wrote the opinion in the Department of Environmental Protection case during versus Ventron.
Yes.
Ventron.
Yes.
Which has had a big impact on environmental work in this state and nationwide. Tell us a little bit about that case. And
well, what it held was that it held a couple of things. It held that under the Spill Act, a liability to clean up the environment could be imposed on prior owners who owned the property involved at a time when pollution occurred. In short, it gave retroactive application to the Spill Act. It also introduced into New Jersey law, or at least recognized in New Jersey law, that under common law principles, as distinguished from a statute such as the Spill Act, that a property owner could be liable to for the cleanup of land, even though the property owner had divested itself of the property. And it generated a lot of litigation. The environmental lawyers in the state were very gracious, and when I left the court, they created an Inn of Court, which they named after me, maybe because I'd generate a lot of work for them, I don't know. But, that case, I had a line in that case that one of my clerks wanted me to take out. He said it was hokey, and I said no. I wanted one line that summarized what I think was a 32-page opinion, and the line was, "Those who poison the land must pay for its cure." Mm. And I left it, stayed in, and when the opinion came out, the New York Times made it the quotation of the day. Mm. Then that opinion also has attracted some attention across the country. Mm.
Now, you had obviously had involvement in environmental issues earlier in your career before going on the Supreme Court. You worked on the Pinelands issues during your time in the Byrne administration. Again, just as an example, how does something like that, your past experience, come to bear on a case like this?
Well, you know, the Pinelands had a different issue, but I really don't think I had much exposure to polluted land before I went on the court. Mm-hmm. The Pinelands, I think, was Brendan Byrne's finest hour, and that there's a whole story that goes along with that. But I mean, that was not so much a case of pollution of land as it was of the development of a very valuable natural resource. And the Governor Byrne, quite correctly perceived the risk and stepped in and controlled it. Mm-hmm.
Now, you had a very important case revolving around liability law, the Spring Motors versus Ford Motor Company case. Tell us a little bit about that.
Well, to understand Spring Motors, I must refer to an earlier opinion, the Henningsen case by Justice Francis, which recognized an implied warranty of fitness and merchantability in the sale of a car to a consumer. Mm-hmm. And that was what that did was it eliminated the notion of privity, so that an injured consumer could sue not just the retailer, the dealer that had sold the car, but could go back to the manufacturer. This today is familiar law, but at the time it was astonishing, and one of the prominent scholars in tort law, Prosser, described it as, I think, the most astounding transition, or I can't recall his precise words, in the history of tort law. So that was the background. Now, Spring Motors involved not a consumer, but a truck dealer, and the car, the truck rather, had a defective transmission. There is one other opinion I should mention, that is Santor versus Karagushin, which took the principle of Henningsen, which involved personal injuries, and applied it to the sale of a carpet where there was only property damage. And while the New Jersey court was deciding Henningsen, Santor, California courts were all similarly addressing those issues. And those issues really were at the forefront of product liability. Our court and the California court parted company when it got to the issue of property damage as distinguished from personal injuries. And we, one of the points that Spring Motors did was point out that when you're dealing with commercial entities, as they were in Spring Motors, that the appropriate vehicle, appropriate set of legal principles to decide those matters was not necessarily tort law, but the Uniform Commercial Code, which applied to transactions between commercial parties. So that was one of the points that Spring Motors decided, and in doing it, it brought us on the issue of damage to property more in line with the California court, with the view of which really had become the majority view in the country. Mm-hmm. But it gave me a chance to revisit all those principles and try to fine-tune the New Jersey law in that regard.
And tell me a little bit about the Dairy Stores versus Sentinel publication case, which...
You know, that involved a newspaper that had said that I think it was a convenience store, or certainly a retail store. It questioned whether they were selling actual bottled spring water or whether the water was tap water, and so forth. And the question was under what set of legal principles can you hold a newspaper, its reporter, and an expert that it had retained. And we decided the case not on constitutional grounds, but on the common law of New Jersey. A principle of judicial process is that if you can decide a case without involving a constitution, that's a good thing to do. That's what you should do, and decide it on a non-constitutional basis. That's what we did in dairy stores. We looked to the common law and said that it's in the public interest that newspapers and the journalists be able to make a fair comment on matters of public interest. And of course, nothing, or very few things, are of greater public interest than the quality of water. So that's what we did in that case. And we also said that this common law notion of fair comment applied not just to matters of opinion, but to matters of fact. So we gave the media some latitude in which to comment on matters of public interest, which we thought was in the public interest, that they have that latitude to do that.
Mm-hmm. Now, around this time, 1986, was when you had your reappointment proceedings. That became controversial. It was talked about quite a bit in the media, and your senator from Morris, I think his name was Dorsey?
Yes.
Yes, was one of the leading voices. Again, as you said, citing the right to choose case as one of the cases he disagreed with you on. Tell us from your perspective what that process was like.
Well, I've always operated on the principle that if you do the right thing, or what you think is the right thing, you need not worry about the consequences. And that pretty much was the principle that guided me through that. I had no doubt about my faith in the opinions I'd written, and I was fully prepared to defend them. And I remember, to get myself psyched up, when I drove down to the Senate Judiciary Committee hearing, I put on, I had a videotape playing, and there's a great old hymn, "Once to every man and nation comes a moment to decide." By the time I arrived at the State House, I felt sorry for my opponents. Whether that was prudent or not remains to be seen. But Governor Kane was the governor at the time I came up for reappointment. Governor Burns' term had ended, and Governor Kane was very kind in reappointing me and supporting the nomination. And I remember I had a call from Mike Cole, who was his counsel, saying, "There's going to be some opposition and you better get some witnesses here to testify on your behalf." I made 3 phone calls, and all three witnesses agreed and actually came down and testified. And it was a pretty good set of witnesses. And it turned out all right. I can't remember. There were some senators, I can't recall the number, but it was 5 or 7 or something like that, who voted against my reappointment. But it ended okay.
Mm-hmm. Going through a process like that, how does that make you feel, particularly? You're a Republican. It's mostly Republicans, leading this opposition.
It really didn't bother me. I felt quite secure in what I had done and was prepared to defend it. And so I don't think I lost any sleep over it.
Mm-hmm. Now, in the again, the media coverage and what the opponents to your reappointment were saying, kind of continues on to this day. The idea of activist judges, in their opinion. What do you think of that concept? And its use as a pejorative.
What I'm about to say may sound excessive. I think it's a phony issue.
Mm-hmm.
Judges make law. That's what we do for a living. And the question is not whether a judge is, at least so it seems to me, is activist in making law or something else, but whether you agree with the law that judge makes. I mean, when a judge relies on the original intent of the Constitution or the plain language of a statute, I suggest you ought to see what that leads, because judicial decisions, particularly those that affect public interest, are inevitably pragmatic. And it seems to me that people who select concepts such as original intent or literal language of a statute like those doctrines because where they lead. And that sounds to me as if it's activist, but so be it. So I think again. I think the key is not so much to get tied up in the nature of the analysis, but to what results that analysis leads, and it need not lead to a particular result in every case, just in most of the cases. So.
Another case I wanted to discuss was the Greenberg versus Kimmelman case. Tell me a little bit about that case.
Well, that, in a sense, that's a sequel to Right to Choose against Byrne. It involved the state's involved the power, if you will, to control the conduct of a judge and a judge's spouse. I think the issue was whether the judge's spouse could work for a casino. We had some restrictions on what judges, on the relationship of judges and casinos, and the legal principle that was involved in that case was equal protection. And as I mentioned earlier, there is no express doctrine of equal protection in the New Jersey Constitution, unlike the 14th Amendment of the United States Constitution. But we've always had notions of equal protection in the first, I think it's Article 1, Section 1 of the New Jersey Constitution. And so Greenberg against Kimmelman provided the opportunity to explain that and what the nature of equal protection of the laws was under the New Jersey Constitution.
In that case, the Greenberg was a spouse of a judge down in South Jersey.
Yeah, right.
Yeah.
Yes.
And her right to work in the casino industry was below the right of the public to have.
Yeah, I think we said it was not a fundamental right.
Okay.
That's my recollection.
Right. Let's see. Spring Motors. Yes. The next case I want to discuss is State versus Martin, which dealt with felony murder and its definition, I believe. A lot of the cases we've been discussing have been more of a corporate nature,
civil
or
case.
Civil. This is a criminal case. Can you talk about that side of the law?
Yes. Were it not for the prescription against discussing publicly the inner workings of the court, there's an interesting story behind it, but I'm not going to get into that. Martin was a young man who went to a party where one of the guests had passed out. I think there was excessive use of drugs and alcohol. He decided to leave, and there was a fact issue. A fire developed, and in the fire, this young woman was asphyxiated and died. Martin had started the fire, and there was a different disagreements between his position and that of the state. The state said, I think he had done it intentionally. He said it happened accidentally, and in any event, the notion, the underlying question was, to what extent can you hold someone responsible for a resulting death from a fire when that person did not intend to cause the death, but intended only to start the fire. And felony murder is a fascinating legal doctrine. and the contours of which has changed over time. Originally, in the early common law, if someone committed a felony and somebody died, that was the end of the analysis. The accused was liable for both the death and the underlying felony. As time went on, and particularly in the 1930s with the American Law Institute, the people began to question the justness of holding someone responsible for a resulting death when that person did not intend to cause the death but to commit another felony. There were a couple of examples that I remember that came out from the ALI. One was somebody intends to rob a bank, walks in and says to the teller, "Stick 'em up." The teller pushes the alarm button and gets electrocuted. And the underlying thought was, in those circumstances, the robber should not be liable for the death because it was so far beyond the foreseeability of the robbery. And then I know there was another example. I think a man intends to kill his wife, invites her away for a weekend. She goes horseback riding, the horse throws her and she's killed. And again, the idea is that this is not something that he would have foreseen, and it was too unrelated. Well, what we did in Martin was we got away from notions of proximate cause, which is a legal doctrine that exists in both criminal and civil law. And what we said was that the test should be whether the connection between the two events, the death and the underlying felony, was so remote that it would not be just to attribute the death to the defendant who had committed the underlying felony. And so what we did was the charge in that case had not recognized those principles, so we remanded it to the trial court for a new trial under a charge consistent with our opinion. Mm-hmm. And I don't know what happened on remand. That's one of the regrettable facts of being an appellate judge, is often you write an opinion setting forth legal principles, sending it back to the trial court to redo the matter, and then, but you never hear what happened on remand.
Now, another big change in criminal law during I think it was the early 1980s when the death penalty was reinstituted.
Yes.
You know, how did that impact your work on the Supreme Court?
My position was that, personally, I did not like the death penalty. I thought it didn't work, and I thought the state should not be in the business of taking human life. I also thought, as a judge, as a justice, that the legislature had the right to have a death penalty as long as it functioned within constitutional limits. The death penalty cases, to me, were the hardest that we had that came before us. I wrote opinions sustaining the imposition of the death penalty. I have no doubt that the defendants had committed the crimes with which they were charged, but nonetheless, I did find it very difficult to do, and I was relieved when the legislature repealed the death penalty.
Now, one of your later cases, I believe, dealt with using DNA evidence.
Right.
So, yes. Yes, State versus Harvey. What do you remember about?
Well,
Which was also a capital case, I believe.
Yeah. what I remember about that was Justice Handler, who I think Justice Handler dissented from the affirmance of every case involving the imposition of the death penalty. So, and he and I had to address, from our very different perspectives, the admissibility of the DNA evidence in that case, because that was key to the imposition of the conviction and of the death penalty on Harvey. And I have not kept up with the current status of DNA evidence. One of the problems with DNA evidence as of that time was it was constantly evolving and becoming more refined. But the question we had to face was whether, in the criminal context, the DNA test as applied in that case satisfied the relevant standard under criminal law. The majority, in its opinion, which I wrote, said yes, and Justice Handler took a different position. But it got me more deeply into DNA evidence and statistical analysis than I had previously.
Yeah, I mean, there were a lot of changes, obviously, in technology and what science could bring into the courtroom. And also, at this time, we're talking about the 1990s, issues of race and other factors were being more brought to the fore in these cases. What, do you recall any of the court's reactions to these newer ideas, I guess, being introduced into cases?
I think our court was sensitive to the role of race in the law, and I know we had an opinion, State against Gilmore. I did not write it. I think Justice Garibaldi wrote it, which talked about the use of peremptory challenges by the prosecution to exclude African Americans, Gilmore pretty vigorously rejected that exercise.
Was that Justice Coleman who wrote that?
I think at that time Justice Coleman was on the appellate division.
Okay.
And he had written the appellate division opinion.
Okay.
And then I think when it came to us, I think Justice Garibaldi wrote it.
Okay. Well, both of those figures were, historic figures in the history of this court and the state because of Justice Garibaldi being the first woman on the court and
Yes.
Justice Coleman being the first African American on the court. Within the court itself, did they bring new perspectives in general?
Well, what I remember most clearly is that their arrival on the court was welcome, and everybody felt comfortable with both Justice Garibaldi and Justice Coleman from the moment they arrived. Fortunately, I had known them both beforehand, and I had the honor of speaking recently at a proceeding in Hudson County where a courtroom and a portrait were dedicated in the honor of Justice Garibaldi. And Justice Coleman remains a good friend to this day.
And you were, I would imagine the two of you were part of the tennis culture on the court.
We did. Well, we both liked tennis, and when we were part of a regular tennis group, we had a doubles group that involved the best tennis player among the three of us was Burl Ives Humphreys. And our fourth, I think, changed from week to week, but we would regularly play. And I had the great pleasure of sponsoring Justice Coleman's membership here in the Morristown Field Club when he decided to join. So.
It sounds like the spirit of congeniality and camaraderie continued regardless of, who came on, what party they were from, and so on.
I think we did get along, but if you take 7 intelligent, dedicated, motivated people and give them controversial issues, it's inevitable there are going to be differences.
Mm-hmm.
But I think I can safely say that those differences were primarily intellectual differences and did not affect personal relationships on the court. I know in my opinions and in my relationships with the other justices, I strove to be polite, even when I was wound up and ready to dissent or ready to respond to a dissent, because there's always tomorrow, and it is a closely knit group. I think even though we may have disagreed with each other vigorously, we made a point of getting along.